Hi everyone, and thanks for joining me once again for the third and final course of Copyright 101. This class will be covering U.S. statutory reversions, notices of termination, the Music Modernization Act, and the 4 factors of fair use. I want to talk a little bit about U.S. statutory reversions. These were enacted into copyright law as a way for songwriters who had entered into deals that weren't very favorable for them to be able to undo those deals years later by terminating a grant of copyright. Now, you'll remember in class 2, we talked about co-publishing agreements, and a lot of those co-publishing agreements were for life of copyright. The songwriters are able to terminate a grant a specific amount of years after that grant of copyright by filing a notice of termination with the Copyright Office. The Section 304C of copyright law allows for termination of works that were registered or published prior to January 1st, 1978. The author or heirs may terminate 56 years after the date of registration or publication, and those works may be terminated during what's called a 5-year termination window, beginning 56 years after the earlier of registration or publication. And the reason that there's this window of time is so that the grantee can negotiate with the songwriter to perhaps work out a better deal if that grantee is interested in still retaining that copyright. Grants by will or work for hire cannot be terminated. You might remember we talked about work for hire in class 2, and those are works where the songwriter doesn't have any copyright ownership. It's owned by the publishing company that hired the writer. And it must be served on grantee no more than 10 and no less than 2 years before effective date of termination. So Section 203 applies to post-1978 works. The author or heirs may terminate 35 years after the date of the grant is executed. But unlike 304C, the termination is based on the date of the grant rather than the date of registration or publication. Like 304C, it must be served on the grantee no more than 10 and nor less than 2 years before the effective date of termination, so as to give the grantee that termination window to negotiate should they choose to do so. If the author dies prior to the termination date, the copyright rights are vested in the heirs. And it's also very important, this applies to 304C as well, that a termination notice be recorded and acknowledged by the Copyright Office. And very specific steps need to be made or the rights will remain with the original grantee if the songwriter or heirs filing the notice of termination doesn't follow the exact steps and file within that time period. And I want to talk a little bit about fair use. Fair use is a legal doctrine that promotes freedom of expression by permitting the unlicensed use of copyright-protected works in certain circumstances. The Copyright Act of 1976 included a provision that some uses of protected works used without permission from copyright owners should be considered fair use. And these are determined on a case-by-case basis. And it's usually brought up in an infringement situation. The 4 factors of fair use that are used by courts to determine whether or not a use falls under this category are the purpose and character, including whether such a use is of commercial value or is for nonprofit educational purposes, the nature of the copyrighted use, the amount of the portion used in relation to the work as a whole, and the effect of the use on the potential market value of the copyrighted work. One of the most famous court cases about fair use is Campbell versus Acuff Rose Music, Inc. So the band Two Live Crew wrote a parody version of Roy Orbison's Pretty Woman, and it was very risque. The publisher of Roy Orbison's denied permission to release it, but Two Live Crew went ahead and released it anyway. As a result, Acuff Rose Music, Inc. sued for copyright infringement. The district court granted summary judgment for Two Live Crew, holding that their song was a parody that made fair use of the original song. The Court of Appeals reversed and remanded, They said that claiming the song was a parody was unfair by taking the heart of the original and making it the heart of a new work. Two Live Crew had taken too much under the third factor, which is the amount used in proportion to the original, and also the fourth factor, that it caused harm in the marketplace for the original. It finally reached the Supreme Court. The Supreme Court ruled in favor of Two Live Crew. They declared that the Court of Appeals had erred in their decision that Two Live Crew had used too much of the original, as this was necessary to create this parody work. They also found that the Court of Appeals had erred regarding Factor 4, the effect on the marketplace, as the public was not likely to confuse the Roy Orbison original with the Two Live Crew version. Next, I want to talk about a very important act that was passed in the U.S. on October 11, 2018, the Music Modernization Act. And this is a sweeping overhaul of the way that mechanical digital royalties are collected, and among other things. But we're going to focus on Title I, which is downloads and streaming, as that relates the most to music publishing. So I want to provide a little background about why the Music Modernization Act was passed and why it was so desperately needed as regards Title I, which is downloads and streaming. So digital service providers like Apple and Spotify had been responsible for identifying rights holders and paying them mechanical royalties. And per copyright law, if they were not able to locate the correct rights holder for a song, they could file what's called a notice of intent at the Copyright Office, which would protect them from any copyright infringement, showing that they, had made a good faith effort to find the rights holder and pay them and request a mechanical license. So the digital providers had really taken advantage of this process of filing bulk NOIs with the Copyright Office, and it created a huge backlog at the Copyright Office, and rights holders, of course, were not getting paid on these works. Effort was made by songwriters, publishers, and music rights organizations for a reform and a streamlining of the licensing process as regards to digital royalties. And this resulted in the Music Modernization Act and the creation of what was called the Mechanical Licensing Collective. So with the passing of the Music Modernization Act and the establishment of the Mechanical Licensing Collective, it established a blanket licensing system for digital music providers, meaning downloads, interactive streams, etc., and it eliminated that practice of the bulk NOIs being filed by the digital music providers at the Copyright Office. So the Mechanical Licensing Collective, and known as the MLC for short, is a nonprofit, and it was established to administer these blanket licenses for the DSP, the digital service providers. The MLC administers blanket mechanical licenses to eligible streaming and download DSPs in the United States. They are not involved in any other types of licenses or royalties, including public performance licenses or royalties, synchronization licenses or royalties, or record, on the master side, royalties. They built a publicly accessible database that lists the rights holders. Anybody can look and see who has the rights on a song. You don't need an account to look it up. And I provided a link for more info on the MLC. I hope you've enjoyed these presentations and have learned a lot about copyright as it pertains to the U.S. If you have any questions about anything, please go ahead and contact me at either my work email or my home email. Thanks so much.